Let's talk about patent searching. You have an invention idea. Should you conduct a patent search? Let's talk about that. So if you have an idea for an invention and you intend to file a patent application, I believe it's always a good idea to conduct some type of a search. Even though you might think your idea has never been done before, you have to keep in mind that there's millions of patents and millions of patent applications, not just at the USPTO, but in patent applications in patent offices all over the world. Unfortunately, there's a very, very good chance that the idea that you have has been done before, at least in some aspect. Maybe not exactly the same way, but there may be some aspects of your idea that are present in patent applications or issued patents. And so it is a good idea to take a look. Now, my recommendation would be you don't necessarily have to start looking at patents initially. Depending on what your idea is, it might be a good idea just to do an initial search using a search engine like Google or Yahoo or whatever search engine you prefer to use. You could conduct a basic search engine search using keywords, in other words, words that are related to what your invention is. You can type a description, a plain language description, and just see what comes up. And I would look at the images and look at different catalogs and see if there's anything for sale that looks like what your invention is. And you'll kind of get an idea of whether your idea really is novel and non-obvious or not. Now, let's say you conduct a search like that and you find something that's directly related to what your idea is. Should you stop at that point? Not necessarily. Patentability really depends on very specific aspects of what your inventive subject matter is. So you could be creating an improvement to something that's already on the market, but your improvement to that product, whatever that product is, may be patentable subject matter and it may have a value in the marketplace. So just because you found something that's similar to the idea that you have shouldn't be a discouragement to you to stop you from inventing or to stop you from pursuing the idea. The other thing I want you to keep in mind too is that patents are not the end-all be-all for selling products and developing products. Just because something may not be patentable, and it may not be, it doesn't mean that it's not a great idea. And it doesn't mean that it's not an idea that you can market, sell, and profit from. It doesn't mean that it's not a great idea. It may be a great product idea. It may have market demand, and it may be something that you can sell in the marketplace, even though you may not have patent protection on it. So the idea that something not patentable is not a good idea is a conflict. A good idea doesn't have to be a patentable idea, and a good product idea doesn't have to be a patentable product idea. So that's something I want you to keep in mind. Patents are not the end-all be-all to whether or not you should make a product and try to sell it. Now, getting back to the idea of patents, if you're convinced that you have something patentable and you really want to know more about what's out there in the patent world, then I would suggest conducting a more detailed search. There are multiple tools that you can use to perform that search, but two of the most useful are probably going to be the USPTO patent search and Google Patents. Google Patents is a very easy tool to use. It's not a complicated user interface. You can enter keywords into it and get a lot of information that way. The USPTO search engine is a little bit less user-friendly, but it's a very good tool, and I can go into more details about how to use these tools in future conversations. But the main thing that you're going to want to do if you conduct this kind of a patent search is to use keywords and what's called Boolean logic. And Boolean logic just means and or not, but you can just get by with and or initially. You don't have to be too sophisticated in how you structure these searches. Let's say that your application is related to electronics. Let's say that your application is related to radio. You could search radio and another specific thing that it's related. Let's say that your invention is related to radio antennas. You could search radio and antennas and you would get a large number of results. And the way you could narrow the results is by adding on additional and statements that would add additional keywords. So it might be radios and antennas. Maybe it's a certain type of antenna. So maybe it's a directional antenna. So radios and antennas and directional, and you would be narrowing the search that way. The other thing is you can use or functions where you're not sure what the term might be, what the right term might be. So you can put a parenthetical, this term or that term, and something else. And there are different ways that you can construct these Boolean searches. But the main point is start with keywords and see what kind of results you get. And you can kind of start to look at them and get a feel for whether your invention might be disclosed in one of these patents or patent applications that exist. A more sophisticated way to conduct a search is to determine what technology class and or subclass your invention belongs in and do a search using the class and subclass information. Now, the USPTO tool would allow you to do that most easily. So you're going to want to pick the tool that's going to give you the most flexibility. And as you get into more sophisticated kinds of searching, you may want to select one tool over the other if that tool provides more flexibility in the type of search terms that you can use when conducting the search. But in general, any of these tools probably will work to do the basic search that I'm suggesting. So you take a look, and what you're going to want to look at when you do that search is not the claims of the patents or the patent applications that you find. You're going to want to look to the specification and drawings to determine whether that might be what's called prior art. So it's a good idea to know how patent examiners examine patents when you conduct that search. And so to have a better understanding of how a patent examiner would look at your patent claims, take a look at my video here on patent examination. That will give you a clearer idea of what a patent examiner looks for when examining your claims, and it will also help you to understand what you should be searching for when you're looking for prior art. Now, that said, you're going to want to have kind of an idea of what you might be claiming, and so to help you with that determination, take a look at my video here on invention analysis. Now, you're not going to have to know the exact format of what your claim is or exactly what language is going into your claim, but it's good to have as close of an idea to what that claimable subject matter might be so that when you're looking at these patents that you're conducting the search on, you have an idea of what you're looking for. You're looking for the features that make your invention different from everything else, or at least at the time you're searching, those are the features that you believe are different from everything else. So if you find something that's talking about those features, you might not have novelty. Now again, this isn't something that should lead to your discouragement. This should be information that's useful to you. So if you find that your invention isn't novel, then you might have to do a little bit more work at the drawing board to get to the point of novelty. Maybe you can develop something a little bit different than what you were initially thinking. In other words, conducting the patent search can allow you to pivot in terms of what your invention is and what the inventive subject matter is, and come to the conclusion of a different idea or a different invention that might be patentable if the initial idea wasn't patentable. Now, doing these patent searches is not an easy task, and it might be helpful to have a patent attorney help you with that. But again, there's also a cost consideration. If you get to the point where you're ready to talk to a patent attorney to discuss the possibility of filing a patent application for your invention, don't rule out the idea of having that patent attorney or some other organization perform the patent search for you. Performing an invention analysis of the subject matter that you believe to be your invention to determine at least an initial set of claims would be very helpful in conducting a patent search, and then having that patent search done around what that claimable subject matter might be can give you a very good idea of whether your invention may or may not be patentable, and most importantly, can save you a ton of time and money. If you file a patent application without having conducted any search whatsoever and you really don't know what's in the prior art, the odds are much higher that you're going to get a novelty rejection or an obviousness rejection with very strong references that are going to be very discouraging in terms of your potential for patentability. And so you can get a lot of mileage, even though there may be an initial cost involved in having a patent search conducted, whether the patent attorney does it, you do it yourself, or you have another party do it. The cost of getting the patent search done can be in the noise compared to what it costs to file a patent application, the preparation and prosecution, and then find out at the end of the process that you don't have patentable subject matter. So I would, in almost all cases, recommend getting some kind of a patent search before you proceed with the preparation and filing of a patent application.